Welcome to Paul Weiss Waking Up with AI, a podcast from Paul Weiss featuring your host, Catherine Forrest. The only update you need on AI policy, law, and governance starts now.
Hello, everyone, and welcome back to Paul Weiss Waking Up with AI. I'm Catherine Forrest.
And I'm Scott Caravello. Catherine, we've got another guest episode today, and it's a familiar face, or I guess for our listeners, a familiar voice.
Well, because it's John Patton, who we'll introduce in a minute I'll introduce him right now. Heads up our IP and technology practice in the UK. And so he's all things AI in the UK. But now that he's been on, John, now that you've been on like at least one prior episode, you don't get spared from our banter, because when we see things in a person's office that we're looking at that our audience can't see, we have an urgent need to talk to them about it. And I just want to mention that you're the only person in the world, and I mean the world, where I see a diffuser. I see one of those like scented diffusers right there on that bookcase near your window. Like, what's going on here? What kind of smells do they have over there in London that requires a diffuser in your office?
Catherine, it's very important to put out the gifts for my wife. But also, there's a saying that tidy desk, tidy mind. Well, this is, good smells, tidy mind as well. So there you go.
Okay, there you go. Then I was going to ask Scott, have you ever been to our London office?
No, I haven't. I was talking with somebody about it recently and how incredible it is. So I think it's a goal of mine. But, John, I got to say, it's great to have you on for all your AI expertise, but also to have someone to redirect Catherine's fire away from me. So this is great. Loving it.
Well, I was just going to talk about the juice bar that the London office has. Not only do they have like baristas like everywhere and couches and leather couches, it's like the Soho Club, but they also have a juice bar tucked away in some beautiful corner. And anyway, it's just, what a life you have, John, between the nice smelling office and the juice bar, right?
Well, it's got a jukebox with many a Bruce Springsteen song on it, so you can listen to that.
Oh, I didn't even know about that. All right. So anyway, we're going to go back for our audience and just remind them that a couple of weeks ago, we had you on, John, for our EU AI Act episode, and that you have been living and breathing AI regulation on both sides of not only sort of the ocean between here and London, or the pond, as they say, but all things also between the channel, between the UK and Europe. And so we're thrilled to have you back. And this time, we were hoping that you could walk us through what's going on in the UK. So you want to start off with a few words about yourself and we'll get ourselves going here?
Yeah, thank you both, and delighted to be back. So as I mentioned on our previous discussion, my practice involves advising on a number of digital regulations across the EU and the UK. Alongside the EU AI Act, UK AI advice has become a fast-growing part of the practice. A lot of English law is, of course, originally derived from the EU, so there are plenty of parallels, but since Brexit, the two are pulling apart more and more, and so AI is no different in this respect.
Yeah, and so, last time when we were talking about the EU, the big headline was the EU AI Act, the big comprehensive risk-based statute and the recent developments around it. And so to your point about them, it seems like the UK story is a very different animal.
Completely different. And so the single most important thing to understand about the UK from an AI perspective is that as of today, there is no AI Act equivalent and no dedicated AI regulator or regulation at all. Whereas Brussels built one comprehensive law and Washington has issued various executive orders, and US states have made some progress on the legislative front, the UK has deliberately chosen not to regulate AI as a single category. Instead, the framework rests on existing laws across IP, privacy, online safety, product liability, etc., each of which is enforced by the existing regulators or the courts.
And is that, John, in your view, a deliberate strategic choice?
Yeah, I think very much so. So a large part of the UK's pitch is that it's a bridge between European, US, and other international markets. English law and the English courts are popular and predictable, and the UK has historically had strong ties to both the US and the EU. So for many businesses, it's a natural conduit between two jurisdictions. That does, however, result in a bit of a balancing act, as a step towards one superpower's approach might mean a step away from the other.
Wait, hold on. Before you go on, Scott, I have to just tell you that, have we ever had anybody here speak in an English accent who uses the word conduit in that way? I could listen to John just repeat that word conduit like 20 times. It would be just fun.
I'm very happy to play my part.
I've rendered you speechless.
Well, we do need to see if we can work, what was it, long stop date? Was that the term we got hung up on last time?
Right.
We got to work that in there. Yeah. But, before we get into the nitty gritty of the regulation or, the balancing approach, maybe to set the stage, we can talk a little bit about the commercial landscape in the UK. 'Cause, here we talk about Silicon Valley all the time, but really, the UK is a genuine AI hub in its own right.
Yeah, it really is. After all, DeepMind was born in the UK and pioneered many of the early steps in AI and machine learning globally through AlphaGo, AlphaZero, and AlphaFold. Now, DeepMind is instrumental to Google in their Gemini models. Then we've got Stability AI in image generation, Wave in self-driving, 11 Labs in voice, and Humanoid in robotics, and they're all UK-based. The investment story has only really accelerated since then. So we've just wrapped up London Tech Week with more than £6 billion of new AI investment and around 8,000 jobs announced, including AMD committing up to £2 billion for UK chip design, R&D and innovation, and Nebius deploying £1.7 billion in NVIDIA GPU clusters across 3 new UK sites.
Well, that's actually very interesting because you've got sort of these job announcements and we hear so often about job cuts, but 8,000 new jobs announced, that's a pretty big number. And the UK government is putting in its own money. At least that seems to be the press reports. We were reading about how the government is putting in over $1 billion for something called the AI hardware plan.
Yeah, that's right. So that sum includes £400 million for British-made AI chips and £750 million for a national supercomputer, which is meant to be in place by 2030. That sits on top of the £500 million sovereign AI unit that went live in April, which invests in UK AI startup. There's also another example in the UK government's investment in quantum technology to support AI, with their announcement in March this year for a plan to invest £2 billion in quantum innovation. And this has already shown benefits with large quantum businesses like IonQ already setting up collaborations in the UK.
You mentioned that there's no UK AI Act. And you previewed it a bit before, but there is some regulation in the UK. So how is that being accomplished?
So the answer is that other than kind of specific IP, privacy, etc. laws that govern certain aspects of AI training, use and output, there is no central AI regulation. Instead, the government's focus has been on investment. And this has been via the AI Opportunities Action Plan, which was adopted in January 25. And this is aimed to drive investment to position the UK as the best state partner to the companies building frontier AI. And interestingly, it's actually already shown tremendous steps with compute capacity up roughly tenfold and 5 AI growth zones that are set to generate £28.2 billion in investment and more than 15,000 jobs.
So again, 15,000 additional jobs on top of the 8,000 jobs. So really interesting stuff. And so what I'm also hearing is that the UK is making some serious investment in the AI infrastructure that we've been talking about on prior episodes and also pushing adoption. So what's the outlook on that front as we move forward in the rest of 2026?
So from a legal perspective, the way that this is then flowing through is that there's a more conceptual-based regulating for growth bill that's going through the legislature, which is aimed at promoting innovation in regulatory sandboxes. And there's also a live private members bill, as we would call the Artificial Intelligence Regulation Bill, which in theory could take a more centralized approach like the EU AI Act. This proposes a central AI authority with principles-based statutory obligations, e.g. safety, transparency, accountability. That second bill had a parliamentary debate in early June, but it doesn't have our government's backing. A private members bill is generally less likely to become law, but it is a useful marker that there's an ongoing debate about whether the UK should move towards a statutory model.
Let's talk about copyright for a moment. In the United States, everybody has, been talking about the large number of copyright cases, and there's just a host of them now. Many of them are, but not all, have been centralized in the Southern District of New York in the federal court here, and they're looking at the question, among other things, but the central question is whether or not the use of data that might have proprietary interests, as for instance copyright is, can constitute, when it's used for training, fair use. So a use that could occur without permission. And so this is going on in the courts right now and closely watched in the UK as well. And you've actually had some significant decisions make international headlines. So let's start with the legislative side of copyright, since there's been activity in the UK on that, and then cover, where you are on the sort of the judicial decision front.
Yeah, absolutely. So maybe on the legislative side, where we should start, is that this has been a very closely debated area. And the government recently spent 9 months in a consultation considering what updates should be made to the legislation. And the upshot is status quo, nothing changes, which is not unusual for our government. So no new legislation, no new regulator for now.
But that's a change from where the government started, isn't it?
It is. So the government's original preferred option had been one to align to the EU, which is a broad exception to copyright infringement, allowing commercial text and data mining subject to the rights holders being able to opt out. But that was opposed by most respondents to the government's consultation, with only 3% backing that government preference.
So then with that in mind, where does that leave the creative sector, and then what comes next?
So the creative sector has made some strong statements. Elton John has publicly described unlicensed training as theft, and a silent album was released under the names of more than 1,000 artists in protest of using trained data without express permission. But rather than legislate now, the government has set out where it will focus next instead. So that's digital replicas and personality rights, with a consultation launching this summer, the labeling of AI-generated content with a task force due to report in the autumn, and a proposed creative content exchange to make licensing easier.
So that's the legislative side. But how about the judicial decisions? Where are the courts these days?
Okay, so there are 3 court cases to know about. The first is Getty Images and Stability. This is the big training data copyright case that you've discussed before on this podcast. At first instance, in late 2025, Stability essentially won. Getty had dropped its primary copyright claim on the basis that there was no evidence of training taking place in the UK, and lost its secondary copyright infringement claim on the basis that an imported AI model is not deemed to be an infringing copy under English law, really only succeeding on a narrow trademark infringement claim due to certain watermarking. In December, the judge granted Getty permission to appeal, and now the narrow question in the appeal court is what counts as an infringing copy. Given that a model was built using infringing copies of training data, is the model itself an infringing copy, even though it doesn't still store those works? The High Court rejected that, holding that given a model as imported did not still hold the trained data, it is not an infringing copy. But commentators have flagged it's a novel and important point of law with potential ramifications for AI models and software more generally. That appeal is expected to be heard later this year, with a focus on whether things like overfitting or similar memorization techniques will count and bring that model within the realm of an infringement claim.
And so then moving on to the second case, that's a patent case, and that caused a significant shift in the law, right?
Yes, exactly. This is the emotional perception case. So some quick background. The UK patent law says you can't patent a program for a computer as such. And the question, therefore, was whether an artificial neural network required for an AI model falls within that exclusion. The lower courts had gone back and forth on this, but in February, the UK Supreme Court held that although an artificial network is a computer program, it isn't automatically excluded from patentability, which is what the lower courts had decided. In getting there, the Supreme Court aligned the UK test for software patentability to the more permissive test used by the European Patent Office, just noting that that's not an EU institution, which is why the UK is still a member. So for anyone patenting AI inventions in the UK, this is a meaningful opening.
Yeah, and the third case is the one about whether AI can be an inventor. That's been an issue that's been contested in the United States, with the position of the courts in the U.S. Patent and Trademark Office being that inventors must be human, though there's been some guidance now, from the USPTO that says that AI can assist, but really you've always got to have what I'm going to call a human centrally and critically in the loop.
Yeah, exactly. So on the UK side, we've got the same line of cases involving Stephen Thaler that you have in the US, who is the individual behind the landmark AI inventorship case in the US. The settled position is that UK patent law requires an inventor to be a natural person, so an AI model cannot be named as the inventor. That hasn't changed, and this case now simply sits alongside emotional perception as the two bookends of the UK AI and patent spectrum.
Awesome. So with all of that said, why don't we finally just sort of turn to online safety? And I think if you wouldn't mind, maybe it would be helpful to put the UK, EU, and US approaches side by side.
Yeah, absolutely. And it's an area that's moving fast. So, like many jurisdictions, the UK has gone hard at non-consensual intimate imagery across both nudifier apps and sexual deepfakes. Since February this year, it's been a criminal offence in England, not just to share, but also to create and even to request the creation of a sexually explicit deepfake without consent, even if it's never shared. The government is also moving to criminalise supplying the nudifier tools themselves, and sharing is already an offence under our existing Online Safety Act.
And maybe you can shed some light, because I had also seen what seemed like a very significant announcement about children's access to social media in the UK.
Yeah, so on the 15th of June, the government said that from spring 2027, it will ban under 16s from social media, which is a situation we've seen in Australia and other jurisdictions. Romantic companion chatbots will also have to enforce an 18-plus age limit, and intimate functions will be restricted for under 18s. Ofcom, who is our regulator for the communications industries, has also been told to fast-track its work on age assurance. So we have the UK criminalising creation of this content, leaning on the Online Safety Act and data protection law. The EU AI Act, then, which is what we discussed last time, goes at it differently through an outright prohibition on the nudifier apps and on general purpose image and video models put on the market without safeguards. And as we discussed last time, that bites from December this year under the Digital Omnibus.
That's really interesting, particularly the entire social media ban that takes effect in the spring of 2027 and all of the other pieces. But, in the U.S., we have the Take It Down Act, which focuses on the publication and platform takedowns of, quote, non-consensual intimate imagery, end quote, rather than its creation.
Yeah, so I guess it's the same harm that is being looked at across both the UK, EU and US, but it's just being dressed in three different ways, which is exactly the type of fragmentation our multinational clients are now having to navigate.
Right. I mean, that's why, when we talk about different AI regulations, getting the perspective of lawyers from different jurisdictions, John, just like yourself, are really necessary, because it's critical to pull it all together, because there are different threads in different places affecting different areas of the law.
So I guess if I were to summarize then where we are with the UK, so the overall picture is the UK is positioning itself as pro-innovation and sector-led, with no big EU-style AI statute. And instead, more and more energy is going into investment, sandboxes, and getting regulators to lean into growth. The UK's bet is to be the conduit, well, there you go, saying it again, between the EU's more prescriptive, comprehensive regime and the more market-led approach in the US. For our clients, the practical question is the familiar one for multinationals, not just in AI, but in other sectors. Do you localize compliance to each regime or generalize to the strictest one you're caught by?
And so then what's on the horizon to watch?
So I'd say the biggest thing is obviously the Getty appeal, which is expected to be heard late this year with a ruling in early 2027, as well as the government's consultation on digital replicas and an interim report on AI content labeling. These are both areas where English law could do with a bit more certainty, but they're also pretty contentious and will no doubt shape how the UK's AI market develops.
Well, John, this has been fantastic. It's sort of a whole capture of the UK picture at a high level all at once. So thanks again for joining us. We're not going to let you go away forever, because we have to see how the diffuser works and check in on your use of the juice bar. But we've also got some of these developments that we're going to want to sort of circle back to.
Thanks, Catherine. I'll send you a diffuser in the post, and it's very nice for you to have me again. Really great to speak.
All right. Signing off now, I'm Catherine Forrest.
And I'm Scott Caravello. Don't forget to like and subscribe.
Thanks for listening to Paul Weiss Waking Up with AI. Be sure to subscribe in your favorite podcast app to stay up to date on the latest in AI policy, law, and governance. For more information on Paul Weiss, go to our website at www.paulweiss.com.